Please note that this AI-generated podcast is intended solely for general learning and educational purposes. While we strive to ensure accuracy, the AI may occasionally produce errors or incomplete information. We strongly encourage you to consult qualified professionals and conduct your own due diligence before making any legal, financial, or business decisions based on the content presented here. Also, any views and opinions expressed in this podcast are those of the podcast creator alone and do not reflect or represent the views, positions, or policies of any organization, institution, or entity, past, present, or future, with which the creator is or may be affiliated.
Welcome to the Deep Dive. Today, we're wading into, well, a pretty intense legal conflict. It's like a corporate thriller, really, between two big home appliance names, Atomberg and Eureka Forbes.
That's right.
But the really interesting part, the deep dive here, isn't actually about whether a patent was infringed. It's more about this really brutal fight over where the case should even be heard, the judicial battleground itself.
Exactly. Our mission today is to unpack a key judgment from the Supreme Court of India. It basically put an end to this venue war. You know, when competitors sue each other in different courts over the same thing.
Yeah, which court gets the case?
Precisely. And this judgment gives some crucial clarity, especially for IP litigation. It really highlights the power of something called a groundless threat suit. We'll get into that.
Okay, so we're going to look at Atomberg's strategy here, how Eureka Forbes pushed back, and apparently there's a surprising bit of legal history the Supreme Court used.
Oh, absolutely. A really interesting statutory detail. But first, let's just quickly get the basics out of the way, the metadata, if you will.
Right, the necessary details.
So this judgment is dated October 17th, 2025. It's from the Supreme Court of India. The judges were Justice Pamidyantam Srinaarasimha and Justice Atul S. Chandorkar. And importantly, they were unified on this. No dissent.
Okay, unified opinion. And the parties?
The main fight was between the petitioner, that's Atomberg Technologies Private Ltd, against the respondents, Eureka Forbes Limited, and another company, Ranch Polymers PVT Ltd.
And the case numbers themselves?
Atomberg's action was transfer petition C number 1983 of 2025. Eureka Forbes had a counter petition number 2174 of 2025. The source material, interestingly, just mentions learned counsel for the parties, so it's really focused on the arguments, which is perfect for us.
Good. So let's dive into the timeline then. You said this moved fast.
Incredibly fast. From a product launch to the Supreme Court in less than 4 months, it all kicked off on June 20th, 2025. Atomberg launched their new water purifier, the Atomberg Intelon, had some special tech, customizable taste, TDS adjustment, that kind of thing.
Okay, standard product launch.
But then, almost immediately, Eureka Forbes, who are, a major player in this market, they started making moves. But informally at first.
How so?
Allegedly, they started making these oral communications, talking to Atomberg's distributors, retailers, basically claiming patent infringement and threatening legal action.
The classic squeeze play, trying to scare off the distribution chain.
Exactly, trying to choke off sales early. But Atomberg didn't just sit back and wait.
No. What did they do?
They acted fast and strategically. On July 1st, 2025, just days later, they filed the first lawsuit. This was in the High Court of Bombay.
Okay, so they struck first. Was this an infringement suit?
No, and this is key. It wasn't an infringement suit. It was a preemptive move. A suit for groundless threat of infringement filed under Section 106 of the Patents Act.
Groundless threat. So they were basically saying, hey, Eureka Forbes, stop making these threats without backing them up. Put up or shut up and do it here in Bombay.
That's pretty much the gist of it, yeah.
Yeah.
A defensive shield. But Eureka Forbes wasn't just going to drop it. They had their own claims.
Right, they believed Atomberg was infringing.
Yes. They argued Atomberg's product used their patented technologies. And they added this interesting wrinkle. They pointed out that Atomberg's manufacturer, this Ranch Polymers company,
Yeah.
they used to be a contract manufacturer for Eureka Forbes.
Oh, that adds a layer, doesn't it?
Yeah.
Suggests maybe more than just accidental infringement, potential use of inside knowledge, perhaps.
It certainly raises that possibility, adds some spice to the dispute. But the really clever bit, or maybe controversial bit, was how Eureka Forbes launched their counterattack in a different court.
Right, because Atomberg chose Bombay. Where did Eureka Forbes go?
Delhi. And how they established jurisdiction in Delhi is central to this whole case. Remember, both companies have their main offices in Mumbai.
So how did they justify Delhi?
It was pretty simple, actually. They ordered the Atomberg product online, had it delivered to an address in Delhi. They then analyzed it there, confirmed the alleged infringement, and boom, they filed their own lawsuit in Delhi on July 7th, 2025.
Wow, just 6 days after the Bombay suit. And this Delhi suit was the main infringement case.
Yes, this was the substantive suit for infringement under Section 104 of the Patents Act, the offensive sword, if you like, to Atomberg's defensive shield in Bombay.
So now we have the setup. 2 suits, 2 high courts. Bombay has the groundless threat suit filed first. Delhi has the main infringement suit filed second. But based on this, well, arguably manufactured jurisdiction.
Precisely. And that's the dilemma the Supreme Court had to solve. Purely jurisdictional. Should the Delhi suit be moved to Bombay? Or should the Bombay suit be moved to Delhi? It's all about consolidating these things efficiently.
Makes sense. Okay, so let's break down the arguments. Why did Atomberg insist Bombay was the right place?
Atomberg's points were pretty logical. First and most obviously prior filing. They were first to court, first to serve papers. That usually counts for something.
Okay, first in time. What else?
Appropriate forum, or locus standi. Both companies are registered in Mumbai, their headquarters, their main business operations. Everything pointed to Mumbai as the natural center for this dispute.
Which makes the Delhi filing seem even more tactical.
And that was Atomberg's big accusation. Forum shopping. They hammered this point. They argued that creating jurisdiction in Delhi based only on a single online purchase and delivery was, well, an abusive process?
Just manufacturing a reason to be in a different court?
That was their claim. They said it was purely strategic, trying to drag Atomberg onto less convenient ground. And they also pointed out the obvious. Efficiency.
Right, having two courts hear basically the same evidence seems wasteful.
Exactly. The issues, patent validity, infringement, the threats, they overlapped almost completely. Running parallel cases risked conflicting judgments, wasted court time, duplicated effort. Consolidation in the first filed court, Bombay, was the logical way to go.
And I also mentioned the burden of proof.
Yeah, a final point. They reminded the court that regardless of where the case was heard, the onus was on Eureka Forbes to actually prove infringement.
Okay, seems like a strong case for Bombay. So how did Eureka Forbes defend keeping the case in Delhi? They couldn't really deny Atomberg filed first.
No, they couldn't. So they focused on the nature of the suits. Their core argument was, our Delhi suit is the substantive one. It's the main event. Meaning it was filed under Section 104, the actual patent infringement claim. This requires deep technical analysis, expert evidence, complex determinations about patent validity. They positioned it as the legally and technically superior case.
And the Bombay suit?
They basically dismissed it. They called the Section 106 groundless threat suit merely ancillary or procedural, limited in scope, just about stopping threats, not deciding the core infringement issue. They argued it couldn't provide the comprehensive relief needed.
So like, our suit is the heavyweight championship fight, theirs is just an undercard bout.
That's a good analogy, yeah. And they strongly defended the Delhi jurisdiction. They argued that the online sale and delivery did create a valid cause of action in Delhi under the law, specifically Section 104 of the Patents Act and Section 20 of the Civil Procedure Code.
Even if it was just one sale seemingly set up for this purpose?
They argued it was sufficient. A commercial transaction occurred in Delhi, and they added that Atomberg had sort of accepted the form anyway by showing up and filing objections in the Delhi court.
That's a bit cheeky, isn't it? You drag someone into court and then say, see, you showed up.
Well, it's an argument lawyers make. Finally, they also played the complexity card, suggesting the Delhi High Court was better suited for technically intricate patent matters.
Okay, so the Supreme Court has these competing arguments. One side says, first come, first served, natural location. The other says, our suit is more important, the location is technically valid. How did the court cut through this?
Interestingly, they deliberately sidestepped part of the argument. They acknowledged their role under Section 25 of the CPC was limited. It's about transferring cases for convenience and justice, not necessarily deciding which lawsuit had a wider scope or definitively ruling on the validity of the Delhi jurisdiction based on that single purchase.
So they didn't get bogged down in whether the Delhi suit was bigger or better.
Not directly. Instead, they went straight to the statutes. And this is where that fascinating historical piece comes in. They looked at the evolution of the law governing groundless threats.
Ah, okay.
Yeah.
Tell us about that.
Right, so they compared the current Patents Act of 1970 with the old law, the Indian Patents and Designs Act of 1911. Under the 1911 Act, Section 36 had this specific clause, a negatory proviso.
A negatory proviso. What did that do?
It basically said that if a patent holder, like Eureka Forbes here, was facing a groundless threat suit, but then went ahead and filed their own proper infringement lawsuit and pursued it diligently, then the original groundless threat suit was automatically wiped out, negated, it just disappeared.
Wow. So under the old law, Eureka Forbes' strategy of filing the infringement suit second would have killed Atomberg's Bombay case.
Absolutely. The old law essentially said, okay, you made threats, but now you're actually suing for real, so the threat issue is moot. It prioritized the infringement action.
But that's not the law anymore.
Exactly. And this was the crucial point the Supreme Court seized on. When Parliament enacted the current Patents Act in 1970, they created the new Section 106 for groundless threats. And critically, they deleted that negatory proviso. It's gone.
They deliberately removed the part that automatically killed the first suit.
Precisely. The Supreme Court interpreted this deletion as intentional and significant. It meant Parliament wanted the groundless threat suit under Section 106 to stand on its own.
So it has its own independent life. It's not just a side issue.
That was the court's conclusion. The Section 106 suit has an independent cause of action. It's separate and robust, not merely ancillary or procedural, and it isn't automatically extinguished just because an infringement suit gets filed later.
That completely undermines Eureka Forbes' main argument about their Delhi suit being the only substantive one that matters.
It really does. It validates Atomberg's first move in Bombay as a legitimate, independent legal action.
Okay, so once the court established that the Bombay suit had real standing and wasn't just procedural fluff, the rest of the decision flowed from there.
Pretty much. The other facts lined up nicely. Bombay was filed first, July 1st versus July 7th. The Delhi jurisdiction was based on that single online purchase. And everyone agreed the issues in both suits were substantially the same.
So avoiding conflicting judgments became the priority. Did they cite any specific precedent for consolidating the cases?
Yes, they relied on a well-known principle, citing the 2004 case Chitavalasa Jute Mills v. J.P. Rewa Cement.
And what's the principle from that case?
It's essentially about judicial common sense. When you have cases where the parties are basically the same, the underlying facts, the transactions are the same, and the legal issues overlap significantly, you absolutely need to consolidate them. To avoid duplication of evidence, wasting court resources, and most importantly, the risk of two different courts reaching conflicting decisions on the same matter. The Chitavalasa principle says justice and efficiency demand consolidation in such situations.
Makes perfect sense. So tying it all together, what was the final concrete decision from the Supreme Court?
The court allowed Atomberg's petition, the first one, transfer petition, 1983 of 2025.
Which means?
Which means they ordered the Delhi suit Eureka Forbes' infringement case, CS-COM, no feet, 663 of 2025 to be transferred to the Bombay High Court.
So Bombay gets both cases,
Yeah.
and Eureka Forbes' attempt to move the Bombay case to Delhi.
That was dismissed. Their transfer petition, C-No 2174 of 2025, failed. The order was clear. Both suits are to be tried together in Bombay. They also urged the Bombay High Court to deal with any pending injunction applications quickly.
So a clear win for Atomberg on the venue issue. And you mentioned earlier this was a unanimous decision.
Yes, both Justice Narasimha and Justice Chandrakar agreed on the outcome and the reasoning. No separate concurring or dissenting opinions.
Okay, let's zoom out then. What's the bigger picture significance here? What does this ruling mean for IP law, for companies in similar situations?
I think it sends two pretty strong messages. First, it really bolsters the standing of the Section 106 groundless threat suit. It confirms it's not just a minor procedural tool, it's an independent action. If you're a company facing what you believe are baseless threats of patent infringement, maybe oral threats, maybe letters filing a second work, Section 106 suit first is a powerful strategic move. And this ruling confirms that suit won't just be automatically swept aside if the threatener later files an infringement case. It gives the threatened party more leverage.
Empowers the potential defendant in a way. Okay, what's the second message?
It's a clear signal about jurisdiction tactics. The court showed a strong preference for consolidating cases in the court where the first action was filed, especially when the jurisdiction for the second suit feels a bit manufactured.
Like the single online purchase in Delhi.
Exactly. The ruling implicitly discourages relying on flimsy grounds like that just to choose your preferred court, especially when there's a more natural forum where both parties operate, like Mumbai in this case. It prioritizes judicial efficiency and avoiding conflicting outcomes over allowing tactical forum shopping.
So the key takeaway for anyone listening, especially if they're involved in IP disputes.
I think the biggest takeaway is this. In these complex IP battles, filing first matters. This judgment really underscores the strategic value of using Section 106 proactively if you're facing groundless threats. The Supreme Court prioritized preventing conflicting rulings and judicial waste, and in doing so, validated the power of that first filing. It's about defining the battleground early.
Interesting. So it's not just about having the better patent argument, it's also about smart procedural strategy right from the start.
Absolutely. Which leads to a final thought, perhaps something provocative for you to consider.
Go on.
While this ruling might discourage that specific online purchase tactic for creating jurisdiction, it clearly reinforces the idea that the legal system often rewards not just the merits, but also being first to court, first to frame the fight. Does this ruling effectively make the Section 106 threat suit an almost essential opening move for companies facing down aggressive patent claims? Is the race to the courthouse door now even more critical?
A fascinating question. Definitely something to think about the strategy behind the strategy.
It's always a game of chess.
Indeed. Well, thank you for breaking that down for us. A really insightful look at a case that's about more than just patents.
My pleasure.
And thank you for tuning into the deep dive. We'll catch you next time.
Thanks for tuning in to the full episode. If there's any topic or case law you'd like us to cover next, share your suggestion in the comments on our latest video. And if you found value in the podcast, don't forget to like, subscribe, and hit the bell icon to stay updated.